I was packing up my office when Brad Sterling walked in with that smile. You know the one. The smile that says, "Your life is about to collapse." He handed me a single sheet of paper and said, "Your services are no longer required. Effective immediately." 7 years of 80-hour weeks. 7 years of building their patent portfolio from nothing. 1 week before the biggest merger in the company's history. $288 million. And they were cutting me out completely. I walked out quietly. Big mistake. The drive home from Tech Cortex Solutions felt surreal. Austin traffic crawled along Interstate 35, but I barely noticed. My hands gripped the steering wheel so tight my knuckles turned white. 7 years. Gone in 5 minutes. I'd joined the company when I was 26 years old, fresh from a smaller engineering firm, hungry to prove myself in the medical device world. Tech Cortex was nothing back then. Just 15 people crammed into a converted warehouse in East Austin, dreaming about revolutionizing glucose monitoring for diabetic patients. The founders, Marcus Brennan and Brad Sterling, were charismatic guys with big visions but zero technical expertise. That's where I came in. My title was patent engineer, but that barely covered what I actually did. I designed the core technology. I ran the experiments. I filed every single patent application myself, working through countless nights perfecting the claims, anticipating challenges, building an ironclad intellectual property portfolio. 32 patents over 7 years. Each one a piece of my soul. I watched that scrappy startup transform into a 300-person company with a gleaming new office building in the domain. I was there for every milestone. When we got our first FDA approval, I cried in the bathroom because I hadn't slept in 3 days. When we landed our Series B funding at $60 million, I was presenting technical data to investors while Marcus took credit for my work. I told myself it didn't matter. I was building something important. The personal cost never seemed to matter either. I missed my younger sister Emma's wedding because we had a patent deadline. My boyfriend of 4 years, Tyler, left me because I chose late-night lab work over his birthday dinner one too many times. My college friends stopped inviting me places. My entire identity became Tech Cortex. When people asked what I did for fun, I had no answer. 2 months ago, Marcus called an all-hands meeting and announced the merger. MedTech Global, a massive medical device conglomerate based in Dallas, was acquiring us for $288 million. The room erupted in cheers. People hugged. Champagne appeared. Marcus gave a rousing speech about how we'd change the world together. I assumed I'd be part of the transition team, maybe even get promoted to Chief Technology Officer. I'd earned it. Instead, 3 weeks ago, Brad started avoiding eye contact. He stopped responding to my technical questions in meetings. Last week, Marcus didn't reply to any of my emails about the merger timeline. Then today, that termination letter, that smile. When I got home to my small apartment near Barton Springs, I sat in my car for 20 minutes before going inside. The reality was sinking in. No job, no plan, no identity. My phone buzzed. Email from HR. Subject line, severance package and exit documentation. I opened it with shaking hands. 6 weeks of pay, standard benefits termination, health insurance through the end of the month, and 17 pages of dense legal documents. Non-compete agreements, confidentiality clauses, and buried deep in Section 12, subsection 4, a requirement that I assign all rights to any intellectual property created during my employment. Something about that clause made my stomach turn. I'd never signed anything like this when I started. The company had been too small, too disorganized. We didn't even have an HR department back then. It was just Marcus, Brad, me, and 12 other people working out of a warehouse with questionable electrical wiring. I called my friend Lauren Murphy. We'd gone to graduate school together, and she'd ended up at a mid-sized law firm in Austin doing corporate work. She answered on the third ring. "Jordan?" I heard. "I'm so sorry. Can you look at something for me?" 20 minutes later, she was at my apartment, reading through the severance documents on my laptop. Her expression grew increasingly concerned. "Did you ever sign an employee IP assignment agreement when you started?" I tried to remember. Those first weeks were chaos. Filling out tax forms, setting up direct deposit, diving immediately into technical work. "I don't think so. I don't remember signing anything about patents." Lauren's voice went quiet. "Jordan, whose name is on the patent filings?" The question hit me like ice water. I pulled up the USPTO database on my laptop, searched for Tech Cortex patents, started scrolling through the results. Patent number 9,400,112. Glucose monitoring system with continuous feedback. Inventor, Jordan. Applicant, Jordan. Patent number 9,600,893. Subcutaneous sensor array with biocompatible coating. Inventor, Jordan. Applicant, Jordan. I went through all 32 patents. Every single one listed me as the sole inventor and applicant. That was correct under patent law. You have to list the actual inventor. But typically, employees sign assignment documents transferring ownership to their employer. Without those assignments, legally, the patents were mine. "Lauren, what does this mean?" She stared at the screen, then at me. "It means the company doesn't own their own patent portfolio. Without these patents, their medical devices are unprotectable. Anyone could copy the technology. The merger is based entirely on the value of this intellectual property. If they don't legally own it, the deal falls apart. But I worked for them. Surely they own it somehow, not automatically. Patent rights belong to inventors, unless explicitly assigned in writing. If you never signed an assignment, and your employment contract didn't include IP provisions, then legally these patents are yours." My brain couldn't process this. That can't be right. There must be something. "Don't sign the severance agreement." Not yet. This changes everything. After Lauren left, I stayed up all night researching patent law, reading case after case. My laptop screen glowed in the dark apartment. The law was clear. Inventors owned their inventions unless they specifically assigned them away. Without a written assignment, employer rights were limited. By morning, I was exhausted but certain of one thing. I had leverage. The question was, what to do with it? The merger signing was scheduled for 6 days away. I spent that first morning staring at my phone, trying to decide my next move. I wasn't trying to steal from the company. I just wanted what was fair. 7 years of my life. They were cutting me out right before the biggest payday. At 10 a.m., I called Patricia Gomez, the HR director. Kept my voice steady and professional. "Hi, Patricia. I received the severance package. I need some more time to review it with legal counsel." Her tone shifted immediately. The warm sympathy from yesterday vanished. "The offer expires in 48 hours, Jordan. It's quite generous. I understand. I just want to make sure everything is fair." "Fair? You're lucky we're offering anything. You're an at-will employee." I held my ground. "I'll let you know." 3 hours later, my phone rang. Unknown number. "Miss Jordan? This is Andrew Hutchinson. I'm an attorney representing Tech Cortex Solutions. I understand you have some concerns about your severance package." His voice was smooth, practiced. Expensive. I'm just reviewing my options. Of course. We want to make this as painless as possible. What if we doubled your severance? 16 weeks of pay instead of 6. Would that address your concerns? 16 weeks. That was maybe $30,000. They were panicking, but they didn't know I'd checked the patent filings yet. I appreciate the offer. I need to think about it. Miss Jordan, I'm authorized to go higher. 20 weeks. That's nearly 8 months of salary. If you sign today, I need until tomorrow. Tomorrow, then. But this offer expires at 5 p.m. He hung up. I sat there, heart pounding. They were desperate. But why? Unless they'd figured out the patent problem. That afternoon, Lauren called. Her voice was shaking. Jordan, I just got contacted by TechCortex's legal team. They're threatening to sue my firm for tortious interference with a business relationship. They're saying I improperly advised you. What? That's insane. My managing partner is freaking out. TechCortex is a potential client. This could destroy my career. I'm sorry, but I can't represent you anymore. The line went dead. They'd figured it out. And now they were isolating me, cutting off my legal help. My only friend who understood law was being threatened into silence. 2 hours later, another email. This one from Marcus Brennan directly. Subject: Let's talk. The message was brief. He wanted to meet at the office that evening at 7 p.m. Just him and me. To discuss my future. Every instinct screamed not to go. But I needed to understand what they were planning. The TechCortex building was mostly empty when I arrived. Just the security guard in the lobby and scattered lights on the upper floors. Marcus's corner office was on the 5th floor. I rode the elevator up, my reflection staring back at me in the polished doors. Marcus was waiting. So was Brad. The friendly facade was gone. Marcus gestured to a chair. Sit down, Jordan. I stayed standing. You've been incredibly valuable to us, Marcus started. His tone was cold now. But you need to understand something. Those patents aren't really yours. Patent law says otherwise. Brad leaned forward. You were our employee. Work for hire doctrine. Everything you created using our resources, our equipment, our funding belongs to us. This is just a clerical error. The law requires written assignments. There are no assignments. Marcus's face hardened. We made you. You were nobody before this company. Without us, you're nothing. Brad's voice rose. You think you can steal from us? We have millions of dollars and the best lawyers in Texas. We'll bury you in legal fees for the next decade. You'll lose everything. The threats were real, but something shifted in me. 7 years of being talked down to. 7 years of watching them take credit for my work. 7 years of sacrificing everything for their vision. Marcus changed tactics, his voice softening. Look, what do you want? 50,000? 100? Name a number. Let's end this. They still thought this was about money. I want what's fair. I built that patent portfolio. Every single invention. And you're cutting me out like I never existed. Brad exploded. You're a technician. We're the visionaries. We saw the market opportunity. We raised the money. We built the company. You just executed our ideas. Then you won't mind if I take my patents somewhere else. Marcus stood up. You walk out that door without signing those papers, and we will destroy you. We'll sue you for everything you have and everything you'll ever have. We'll make sure you never work in this industry again. I looked at both of them. 2 men who'd built a fortune on my work and were now threatening me for asking for basic fairness. I'm not signing. I walked out. The next morning, I woke up to my phone exploding. Texts, emails, missed calls. I grabbed my phone, still half asleep, and saw the notification from Austin Business Journal. Former TechCortex employee accused of intellectual property theft in stunning lawsuit. My hands went numb. I pulled up the article. TechCortex had filed a lawsuit against me at 6 a.m. Breach of fiduciary duty, theft of trade secrets, fraud. They were seeking $10 million in damages. The article quoted Marcus extensively. He painted me as a disgruntled employee trying to sabotage the merger out of spite. He called my claims baseless and frankly delusional. He said the company was the victim of an extortion attempt. My LinkedIn started flooding with comments. Former colleagues leaving messages about how disappointed they were. People I'd worked alongside for years, now calling me a thief. The Austin tech community was small. Everyone was seeing this. My mother called from Dallas crying, "What's happening? Are you okay? Do you need money for a lawyer?" I couldn't answer. I couldn't process any of it. I needed legal help immediately. But who would take my case? I called 5 patent attorneys that morning. All 5 declined once they heard TechCortex was the opponent. The company had deep pockets and connections throughout Austin's legal community. Going against them was career suicide. By afternoon, I was desperate. I found Harrison Blake through an online search. He was 62 years old, running a small patent practice out of a converted house near the University of Texas campus. His website hadn't been updated since 2010. His office was cluttered with law books, file boxes stacked everywhere, diplomas from the 1980s on the walls. He looked like someone who'd stopped caring about impressing clients decades ago. I explained everything. He listened without interrupting, taking notes on a yellow legal pad. When I finished, he sat back in his creaky chair. "You're legally right. The patents are yours. But they're going to make your life hell. Are you prepared for that?" "I don't have a choice." "You always have a choice. You could walk away, sign their papers, move on with your life. After what they've done?" "No." He studied me for a long moment. "My retainer is $50,000. That'll get us through initial filings and discovery. If this goes to trial, you're looking at another $100,000 minimum." I didn't have $50,000. I had maybe $12,000 in savings and decent credit. I put $30,000 on credit cards, emptied my savings account, and borrowed $15,000 from my parents, who couldn't really afford it. Harrison filed our countersuit 3 days later. We claimed ownership of all 32 patents and demanded an injunction preventing the merger until the dispute was resolved. We also claimed a share of the merger proceeds, arguing that TechCortex had built their entire value proposition on my inventions. The merger was officially placed on hold. MedTech Global issued a terse statement expressing concern about unexpected intellectual property complications. Their stock dropped 3% in one day. TechCortex's stock, which had soared on merger news, plummeted 18%. The pressure on me intensified immediately. Anonymous emails started arriving. Threats, accusations. Someone posted my home address online, along with claims I was trying to steal millions from hard-working employees whose stock options now meant nothing. I found my car keyed in my apartment parking lot. Deep scratches all along the driver's side. The word thief carved into the paint. I stopped sleeping. Every noise in my apartment building made me jump. I stopped going to my favorite coffee shop because people recognized me and whispered. Then Harrison called with news from the discovery process. "They're claiming you signed an IP assignment agreement. First week of employment." My stomach dropped. "That's impossible. I never signed anything." "They've produced a document, dated July 15th, 7 years ago, with your signature." He emailed me a scan. I stared at the paper. It looked official. Tech Cortex letterhead. An employee intellectual property assignment agreement. My signature at the bottom. The signature looked like mine. The document appeared real. If this holds up, you lose everything, Harrison said quietly. They own the patents. The countersuit collapses. You're left with nothing but their $10 million judgment against you. I was looking at the document, panic rising. Then I saw the date, July 15th, 7 years ago. Harrison. I started work on July 22nd, not July 15th. I remember because it was a Monday, and I'd taken that week to move from Houston. Silence on the phone. Are you certain about that date? Absolutely. I have emails. I have my apartment lease. I wasn't even in Austin on July 15th. Then, this document is a forgery. My rage burned cold. They weren't just fighting dirty. They were committing fraud. Can we prove it? We'll need a forensic document examiner. That's another $10,000. Money I didn't have. But I sold my grandmother's pearl necklace, borrowed more from my sister Emma, and scraped together the funds. Dr. Helen Rodriguez was the forensic document examiner Harrison recommended. She worked out of a small lab in South Austin, analyzing questioned documents for criminal cases and civil litigation. Her credentials were impressive, but her fees matched. I met her on a Tuesday morning, handing over the scanned copy and asking how long the analysis would take. 3 weeks minimum. I need to request the original document from the court, examine the paper stock, ink composition, signature characteristics. These things take time. 3 weeks felt like forever. The merger deadline was approaching. Tech Cortex's lawyers kept pushing for expedited hearings. MedTech Global was getting impatient, threatening to walk away if the uncertainty continued. During those 3 weeks, the pressure never let up. Tech Cortex's lawyers sent me a settlement offer. Drop all claims, walk away with nothing, and they'd dismiss their $10 million lawsuit. The message was clear: give up or be destroyed. Marcus gave an interview to the Austin American-Statesman. He talked about the stress this was causing loyal employees, how their stock options were worthless while this dragged on, how families were suffering because of one person's greed. He never mentioned my name, but everyone knew who he meant. The company's stock continued falling. Down 23% now. Angry shareholders were filing their own lawsuits against Marcus and Brad for mismanagement. I couldn't find work anywhere. My reputation in the Austin tech scene was destroyed. Applications went unanswered. Recruiters stopped returning calls. I was burning through credit, falling deeper into debt. Finally, Dr. Rodriguez called. Harrison and I drove to her lab. She spread her analysis across a light table, pointing to magnified images of the signature. This document is definitely a forgery. The ink doesn't match the paper age. The paper stock is consistent with documents from 7 years ago, but the ink shows characteristics of material manufactured within the last 6 months. Someone signed this recently, trying to make it look old. She pointed to another image. More importantly, the signature shows characteristics that only appeared in your writing after an injury. You mentioned breaking your wrist 4 years ago? I nodded. Rock climbing accident at Reimer's Ranch. Compound fracture. 6 months of physical therapy. Your signature changed after that injury. The angle of your downstrokes, the pressure distribution, specific letter formations. This signature shows those post-injury characteristics. It's physically impossible you signed this 7 years ago. Harrison smiled for the first time since I'd met him. That's enough. We've got them. He filed the forensic report with the court, along with a motion to strike the forged document and impose sanctions on TechCortex for fraud. I thought we'd won. 2 days later, TechCortex fired back with something I never expected. They produced electronic records from their old HR system showing I digitally signed the IP assignment agreement on my first day of work. The electronic signature system captured my IP address, timestamp, even my employee ID number. The metadata looked completely legitimate. Harrison called me, confusion in his voice. How can we have a forged paper document and a legitimate electronic signature of the same agreement? I never signed anything electronically. I don't even remember them having a digital signature system back then. He dug deeper. The old HR system had been operated by an external vendor called PeopleTrack Solutions. That company went bankrupt 3 years ago. Their assets, including servers and software, were sold off in bankruptcy auction. Harrison discovered something interesting. TechCortex's current IT director was a guy named Simon Cross. He'd been hired 2 years ago. He was also Brad Sterling's college roommate from Rice University. They fabricated the electronic records after the fact, Harrison said. But proving it means finding the old servers and showing the signature was backdated. The bankruptcy auction records showed the servers were sold to a data recovery company in Houston called Data Vault Systems. We had to get access to those servers. The merger deadline was 45 days away. We had 15 days to prove the electronic signature was fake or the case was over. Harrison hired a private investigator named Casey Wright, former FBI cybercrime specialist, now working private cases. She charged $200 an hour. Casey tracked the servers to a warehouse in southwest Houston. Data Vault Systems was barely legitimate, operating in a legal gray area of data recovery and storage. We drove 3 hours to Houston on a Saturday. The Data Vault office was in a strip mall between a pawn shop and a payday loan place. The owner, Dennis Park, was in his 40s, suspicious and uncooperative. Those servers are client property. I can't let you access them without a court order. We don't have time for a court order, Harrison explained. We need to examine backup data from a specific date range. Not my problem. Casey stepped forward. $5,000, cash, for 1 hour of access. Dennis considered. $10,000. $5,000 is what we have. He looked at the three of us, then shrugged. Cash only. You've got 1 hour. Touch nothing except what you came for. I didn't have $5,000. I drove to a dealership in Houston and sold my car for $4,000 cash. My sister Emma, who'd driven down with us, loaned me another $1,000. Dennis led us to the server room. Rows of dusty equipment, blinking lights, the hum of cooling fans. Casey got to work, connecting her laptop to the old PeopleTrack backup system. It took 40 minutes of searching through archived data. Then Casey pulled up the logs. Got it. The electronic signature record for your IP agreement was created 18 days ago. Not 7 years ago. It was backdated, but the system logs don't lie. Someone with administrator access created this file remotely from an IP address registered to TechCortex's main office network. Proof. They'd fabricated evidence. Harrison filed an emergency motion that Monday, attaching Casey's forensic analysis. We had them. Criminal fraud, fabrication of evidence, obstruction of justice. The judge scheduled an emergency hearing for Wednesday. I thought it was finally over. Tuesday morning, TechCortex filed for bankruptcy protection. Emergency, Chapter 11. The filing claimed the ongoing litigation had rendered the company insolvent. All assets, including the patent portfolio, were now part of the bankruptcy estate. The merger was officially dead. MedTech Global withdrew their offer. My claim became just another line item in bankruptcy proceedings. I'd have to fight for pennies on the dollar alongside other creditors. The patents would be auctioned off. Marcus and Brad would walk away, probably start another company in 6 months. They were willing to burn it all down rather than admit what they'd done. Harrison's voice on the phone was grim. The bankruptcy hearing is in 3 days. If the judge allows the filing to proceed, this could drag on for years. You'll get nothing. I'd lost everything. My job, my reputation, my savings. And now I was going to lose the one thing that mattered, proof that I'd been right all along. The federal bankruptcy court in Austin was cold and impersonal. Fluorescent lights, worn carpet, the smell of old documents. I sat next to Harrison in the gallery while Tech Cortex's bankruptcy attorney, a sharp woman named Claire Sutton, argued their case to Judge Patricia Morrison. Your Honor, the company is insolvent due to ongoing litigation costs. The uncertainty has destroyed their market value. Bankruptcy protection is the only way to preserve value for creditors and employees. Harrison stood to respond. This is a fraudulent filing, Your Honor. Tech Cortex is using bankruptcy as a sword, not a shield. They're trying to avoid accountability for documented fraud. Judge Morrison, a stern woman in her 60s, reviewed the filings. Mr. Blake, proving fraudulent bankruptcy is an extraordinarily high bar. Do you have evidence the company is not actually insolvent? The litigation costs are a direct result of their own fraudulent actions, Your Honor. They fabricated documents, created false electronic records, and filed meritless lawsuits. They shouldn't benefit from their own wrongdoing. That's an argument for the underlying case, not the bankruptcy proceeding. I'm allowing the Chapter 11 filing to proceed. All litigation against Tech Cortex is stayed pending bankruptcy resolution. All assets, including the disputed patents, are part of the bankruptcy estate. The gavel struck. It was over. I walked out of the courthouse into bright Texas sunshine. The world kept moving. Cars drove past. People walked by checking their phones. My entire life had just collapsed, and nobody else noticed or cared. MedTech Global issued a press release that afternoon. They were officially withdrawing from the merger. Too much uncertainty. Too many complications. Tech Cortex's stock was suspended from trading. Marcus and Brad issued statements expressing disappointment, but looking forward to restructuring the company for future success. I went home to my apartment, sat on my second-hand couch in the silence. I was $80,000 in debt, no job, no car, no prospects. My credit cards were maxed out. My parents had given me money they couldn't afford to lose. My sister had drained her emergency fund to help me. And for what? The creditors started calling immediately. Credit card companies wanting minimum payments I couldn't make. My landlord wanting rent that was now 5 days late. I sat there as the sun set, watching the light fade from my living room, and finally let myself break. I cried for hours. For the 7 years I'd wasted. For the life I'd sacrificed. For the naivety of thinking hard work and being right would matter. At midnight, my mother called. She'd driven from Dallas, arriving at my apartment door 20 minutes later. She held me while I sobbed, not saying anything, just being there. Finally, when I had no tears left, she spoke. You didn't do anything wrong. Sometimes that doesn't matter in this world, but you'll survive this. You're stronger than you know. Something in those words, spoken in my mother's steady voice, gave me a tiny spark. Not hope exactly, but stubbornness. I'd been so busy being afraid, being overwhelmed, I'd stopped thinking clearly. At 3 a.m, I couldn't sleep. I started going through old files on my laptop. email backups from 7 years ago, documents from my first months at Tech Cortex. I found my original employment offer letter. Read it carefully for the first time in years. Section 8. Arbitration Clause. Any disputes arising from this employment relationship shall be resolved through binding arbitration under the rules of the American Arbitration Association. My heart started pounding. I called Harrison, not caring that it was 3 a.m. He answered, groggy. "Jordan, what's wrong?" "The employment offer letter. There's an arbitration clause. Doesn't that supersede bankruptcy in some cases?" Silence. Then I heard papers rustling. Federal Arbitration Act, employment disputes, bankruptcy proceedings. He was thinking out loud. You might be right. Employment arbitration agreements can be enforced even in bankruptcy for certain claims. Patent ownership is a property dispute arising from employment. This is narrow, but it might work. Can we file something? I'll research it. Call you in a few hours. I didn't sleep. At 8 a.m., Harrison called back. It's a long shot, but we can file an emergency motion to compel arbitration. Argue that the patent ownership dispute is subject to your arbitration agreement and should be carved out from the bankruptcy estate. Some circuits have allowed this in specific circumstances. Do it. We filed the motion that afternoon. Tech Cortex fought back viciously. Their attorneys argued the bankruptcy superseded all prior agreements. 3 days of emergency hearings followed. Judge Morrison didn't look happy about any of it. On Friday afternoon, she issued her ruling. The arbitration clause in Miss Jordan's employment agreement specifically covers disputes arising from the employment relationship. Patent ownership falls within that scope. I'm ordering the patent ownership dispute to arbitration. The bankruptcy proceedings will continue for all other matters, but the patents are excluded pending arbitration outcome. It was a partial victory. But arbitration was expensive, and I was broke. That evening my phone rang. Unknown number from Dallas. "Miss Jordan? This is Janet Herrera. I'm the CEO of MedTech Global." I froze. Why was she calling me? "I've been following your case closely. We spent $2 million on due diligence for that merger. We're not happy about Tech Cortex's fraud." "I understand. I have a proposal. MedTech will fund your arbitration, pay all legal costs. In exchange, if you win ownership of the patents, you'll license them exclusively to us. We'll pay you $5 million up front, plus 20% royalties on all products using your technology." $5 million. My brain couldn't process the number. What's the catch? The arbitration must conclude within 30 days. If you lose, you're personally responsible for reimbursing our legal costs. That'll be around $500,000. If I lost, I'd be destroyed financially forever. Bankruptcy wouldn't discharge that kind of debt. Harrison, who'd been listening on speaker, shook his head. "Don't do it. The risk is too high." But what choice did I have? Walk away with nothing? Spend years in bankruptcy proceedings fighting for scraps? I'll do it. Our legal team will contact your attorney tomorrow. Good luck, Miss Jordan. The line went dead. Harrison looked at me like I'd lost my mind. If you lose, you'll never recover from this. Then I won't lose. MedTech's legal team arrived in Austin 3 days later. 2 attorneys from a major Dallas firm, Amanda Chen and Robert Kim. Wait, no, 2 attorneys named Sarah Mitchell and Thomas Reynolds. They were sharp, experienced, and had handled dozens of complex patent disputes. We had 2 weeks to prepare for arbitration. The arbitrator was Thomas Garrett, a retired federal judge known for being fair but absolutely strict about evidence and procedure. The arbitration took place in a conference room at a downtown Austin hotel, neutral ground. Tech Cortex brought 8 attorneys. Their lead counsel was Douglas Pemberton from a massive Houston firm, the kind of lawyer who charged $800 an hour and had never lost a patent case. The stakes were simple. Winner takes all. Douglas presented Tech Cortex's case first. He was smooth, persuasive, commanding the room effortlessly. Your Honor, this case is fundamentally about an employee who wants to claim ownership of work she was paid to perform. Miss Jordan was employed by Tech Cortex. She used their equipment, their funding, their laboratory facilities. The work-for-hire doctrine is clear. Inventions created within the scope of employment belong to the employer, regardless of whether specific assignment documents exist. He presented financial records showing my salary over 7 years, performance reviews describing my work as an employee, witness testimony from former colleagues. A former coworker named Stephanie Harper testified that I was just doing my job like everyone else. Another colleague, David Brennan, Marcus's brother, described how the company's vision drove all the technical development. Then Brad Sterling took the stand. He was polished, confident, described himself and Marcus as the true innovators. Jordan was talented, absolutely, but she was executing our vision. We identified the market need. We developed the business strategy. We directed the technical development. She translated our ideas into patent applications, but the inventive concepts came from us. Douglas asked him directly, "Who conceived the core glucose monitoring technology?" Marcus and I conceived it during a brainstorming session in early 2018. We brought the idea to Jordan and asked her to develop the technical specifications. It was a lie, but he told it convincingly. Marcus testified next. Same story. They were the visionaries. I was support staff. A talented employee, yes, but an employee nonetheless. Douglas's closing for their case was devastating. "Your Honor, Miss Jordan wants to be compensated twice. She received a generous salary for 7 years. Now she wants to claim the fruits of that work as solely hers. This isn't about fairness, it's about greed. The law is clear. Employees don't own their employer's intellectual property. That's true even when assignment paperwork is missing. That's what work for hire means." Then it was our turn. Harrison put me on the stand. I testified for 2 full days. I walked through every single patent, explained how I conceived each invention independently, showed my original laboratory notebooks with sketches, calculations, experimental results, demonstrated the technical knowledge required to develop these innovations. Marcus and Brad had no technical background, I explained. Marcus studied business administration. Brad studied marketing. Neither one understood biochemistry or electrical engineering. They couldn't have conceived these inventions because they didn't understand the underlying science. I showed the arbitrator my development process. How I identified technical problems, researched solutions, designed experiments, built prototypes, refined the technology through iteration. None of it involved input from Marcus or Brad, beyond general business goals. They'd say things like, "We need the device to be smaller," or "We need better battery life." Those aren't inventive concepts. Those are product requirements. I figured out how to actually achieve those goals. That's invention. Douglas Pemberton tore into me on cross-examination. "Miss Jordan, you were paid a salary, correct?" "Yes." "You used company equipment?" "Yes." "Company funding paid for your research?" "Yes." "You knew you were developing technology for Tech Cortex's commercial use?" "Yes." "So you admit you were working for the company, using company resources, with the expectation that your work belonged to the company. I was an employee, but patent law requires actual inventorship. Being an employee doesn't automatically transfer patent rights without a written assignment. How convenient that you're raising this issue now, right before a massive merger payout. I was fired. They cut me out deliberately. I'm fighting for what's mine. Or you're trying to extort a company you worked for, using a technical loophole. Harrison objected. The arbitrator sustained it, but the damage was done. I looked greedy, vindictive. On the third day of arbitration, Harrison played his trump card, the emails we'd obtained from the Houston servers. Brad's email from 3 weeks before I was fired. We need to cut Jordan before the merger. If she's on payroll when it closes, she'll get stock options. That's $5 million we can keep. Marcus's reply. Agreed, but the patents are in her name. We need to fix that. Brad's response. I'll handle it. We'll create the assignment documents after we fire her. Who's going to check? The conference room went silent. Douglas Pemberton's face turned red. He objected strenuously, tried to get the emails excluded as improperly obtained, but the arbitrator allowed them. They were authenticated, relevant, and devastating. These emails show premeditation, Harrison argued. They knew the patents were in Miss Jordan's name. They knew they didn't have assignment documents. Rather than address it properly, they conspired to fire her and fabricate records. This isn't a work-for-hire situation. This is fraud. Despite the emails, the arbitrator seemed troubled. During closing arguments, he asked me directly, Miss Jordan, even assuming Tech Cortex behaved badly, can you definitively prove these inventions were solely yours? Patent law requires conception by the actual inventor. You worked with Marcus and Brad in those early days. Can you prove beyond doubt that they contributed nothing to conception? The question hit me like a punch. Brad and Marcus were there during brainstorming sessions. We'd had planning meetings, strategy discussions. Even if I did all the technical work, maybe they'd contributed something to the inventive concept. Patent law was murky on this. If the arbitrator found they were co-inventors, the patents would be jointly owned. Tech Cortex could still use them. I'd get a share, maybe, but I'd lose my leverage entirely. I'll issue my decision within 1 week, Judge Garrett announced. We left the hotel conference room. Harrison was quiet during the drive back to his office. Finally, he spoke. It could go either way. If he finds any co-inventorship, you lose. That night, I couldn't eat, couldn't sleep. Everything hinged on one man's interpretation of murky legal standards. My phone rang at 11 p.m., blocked number. A woman's voice, nervous and whispering. My name is Amanda Pritchard. I used to work at Tech Cortex. I was Brad Sterling's executive assistant until he fired me 3 years ago. Why are you calling? I've been following your case. I need to tell you something. I have a recording. My heart started pounding. 3 years ago, we had an office party. Brad got drunk, really drunk. He was bragging to me about the company's success. He said, and I'm quoting, Marcus and I couldn't engineer our way out of a paper bag. Jordan's the genius. We're just the mouthpieces. But everyone thinks we're brilliant, and that's all that matters. You recorded this? I thought it was funny at the time. Recorded it on my phone. I still have the file. I was young and stupid. He fired me 6 months later when I refused to backdate some financial documents. I've been afraid to come forward because he threatened me. But what they're doing to you is wrong. Can you provide the recording? I'm terrified of him. But yes. Can we meet? I met Amanda the next morning at a coffee shop near the University of Texas campus. She was 28, nervous, kept looking over her shoulder. She handed me her old phone. I listened to the audio file. Brad Sterling's voice, slurred but clear, admitting that all the technical innovations came from me. Amanda, would you be willing to testify? I don't want to be involved. Can't you just use the recording? It might not be admissible without you verifying its authenticity. She hesitated, then nodded. Okay, I'll do it. But I need protection. I need to know he can't retaliate. Harrison filed an emergency motion to reopen evidence. Judge Garrett was clearly annoyed, but agreed to hear it. We reconvened the next day. The conference room felt different now. Tense. Final. Harrison played the recording. Brad Sterling's voice filled the room, admitting I was the technical genius behind everything. Douglas objected furiously. This is hearsay! It's inadmissible! It's a party statement taken in a private conversation without consent. It's a party admission, Harrison countered. Exception to hearsay. Mr. Sterling is a party to this dispute, and he's making a statement against interest. Judge Garrett allowed it. Brad Sterling, sitting at the defense table, went pale. Marcus looked like he might vomit. Amanda testified briefly, verifying when and where the recording was made. Douglas tried to attack her credibility, but her testimony was simple and consistent. Judge Garrett looked at both legal teams. I'll issue my final ruling within 48 hours. We left. Harrison didn't say anything on the drive back, but for the first time, I saw something in his expression that might have been hope. 48 hours felt like 48 years. I stayed in my apartment, unable to focus on anything. My phone felt like it weighed 1,000 pounds every time it rang. Finally, at 3 p.m. on a Thursday afternoon, Harrison called. His voice was different, lighter. Jordan, you need to sit down. Tell me. You won. Everything. The arbitration decision was 32 pages long. Judge Garrett found that I was the sole inventor of all 32 patents. TechCortex had no ownership rights whatsoever. Moreover, he found the company had committed fraud and acted in bad faith throughout the dispute. He awarded me all attorney's fees and imposed sanctions against TechCortex for their fraudulent conduct. The decision was final and binding. I sat in my apartment, holding the phone, unable to speak. Jordan, are you there? I'm here. I can't believe it's over. It's over. You won. Within hours, the news spread through the Austin tech community. TechCortex's already precarious bankruptcy became a total collapse. The company had no assets left. No patents, no merger, nothing. Marcus Brennan resigned in disgrace. The board announced an investigation into potential criminal charges. Brad Sterling left the state. Rumors circulated that prosecutors were considering fraud charges. The employees, my former colleagues, scattered to other companies. Most had lost their stock options, their promised windfalls. I felt bad for them. They'd believed in Marcus and Brad just like I had, but I couldn't carry guilt for their choices. I'd been fighting for survival. Janet Herrera from MedTech called me the next morning. Congratulations. Our licensing deal is still on the table. $5 million upfront, 20% royalties. You'll join our advisory board as a technical consultant. We'll manufacture your technology properly and get it to the patients who need it. We finalized the contract in MedTech's Dallas office the following week. The check was real. $5 million. More money than I'd ever imagined having. The first thing I did was pay off every debt. Credit cards, personal loans, money borrowed from family. I paid back my parents, my sister Emma, Harrison Blake, everyone who'd helped me. I gave Amanda Pritchard $50,000 for her courage in coming forward. I donated $200,000 to a legal aid fund specifically for patent disputes, so other inventors wouldn't face the same struggles alone. I bought a modest house in the Barton Hills neighborhood. Nothing extravagant. Just a place that felt like mine. I took 3 months off, actually rested for the first time in 7 years. Reconnected with Emma, drove to Dallas to spend time with my parents. Started rock climbing again at Reimer's Ranch, where I'd broken my wrist years ago. I realized how much of myself I'd lost chasing Tech Cortex's vision, how I'd sacrificed relationships, hobbies, health, everything that made life worth living. 6 months after the arbitration, I was invited to speak at a Women in Technology conference in Austin. 500 people in the audience. I was terrified, but I owed it to others who might face similar situations. I told my story, all of it, the highs and the devastating lows. I spent 7 years building something I thought belonged to me, I said to the quiet audience, only to discover the legal reality was murky at best. I thought my work was my identity. Losing my job felt like losing myself. But here's what I learned. The work was always mine, not because of legal documents or patents or money. It was mine because I created it, because it came from my mind, my effort, my sleepless nights. They could fire me. They could try to steal credit. They could make my life hell. But they couldn't take away what I actually did, the value I created, the knowledge in my head. When they fired me, they thought they were cutting me loose, but they were cutting themselves off from the source. I looked out at the audience. Young women, experienced professionals, entrepreneurs, all navigating the complicated reality of building careers in technology. My advice: document everything. Keep records of your work. Understand intellectual property law. Don't trust that good work will automatically be rewarded. Protect yourself legally from day one. But more importantly, know your worth. Not what a company tells you you're worth, what you actually bring to the table. They tried to make me feel small, disposable, and for a while, I believed them. I kept fighting not because I was brave. I fought because I had nothing left to lose. And sometimes that's when you find out what you're really made of. The applause was overwhelming. Afterward, dozens of people wanted to talk, to share their own stories of workplace betrayal, intellectual property theft, being undervalued. I realized my story mattered not because it was unique, but because it was common. So many people, especially women in technical fields, faced versions of this same struggle. Today, I run my own small medical device company. 3 employees so far. We're developing next-generation glucose monitoring technology using patents I've filed under my own name with proper legal structures in place. I've learned from my mistakes. I have an excellent attorney on retainer. Everyone who works for me signs clear intellectual property agreements. But I also treat my employees fairly, pay them well, and make sure they're recognized for their contributions. I'm building something again. But this time, it's truly mine, legally, ethically, completely. Last week, I saw a news article. Tech Cortex officially dissolved. Marcus and Brad are facing SEC charges for securities fraud related to the merger. Their legal troubles are just beginning. I don't feel satisfaction about their downfall. Mostly, I feel sad that it came to this. If they'd treated people fairly, none of it would have been necessary. But I also learned something crucial. Sometimes standing up for yourself means watching everything burn down. Sometimes justice looks like destruction before it looks like redemption. My phone buzzed with a message from Harrison Blake. saw the news. Tech Cortex officially dissolved today. Marcus and Brad facing SEC charges. Justice. I typed back. Thanks for everything. Couldn't have done it without you. Setting my phone down, I returned to my work. New patent applications, new designs, new possibilities. The past was behind me. The future was mine, legally and completely, and I was never working for someone else again. Your value doesn't come from a job title or a company name. It comes from what you create, what you know, what you bring to the world. They can fire you, betray you, try to steal from you, but they can't take away your actual worth. And when you stand up for yourself, even when you're terrified, even when you're broke and alone, even when everyone says you'll lose, sometimes you win. Not because the system is fair, but because you refuse to let them erase you. Document everything. Protect yourself, know your worth, and never, ever let anyone make you feel disposable. Have you ever felt undervalued at work, or had someone try to take credit for your contributions? How did you handle it? I'd love to hear your stories in the comments below. If this story resonated with you, please hit that like button. It helps others find these stories and reminds us we're not alone in these struggles. Subscribe to hear more stories about overcoming workplace injustice, standing up for yourself, and fighting for what's rightfully yours. And please share this with anyone who needs to hear that their work matters, that their contributions have value, and that sometimes fighting back is the only option. Thank you for listening to my story. I hope it gives you strength when you need it most. Remember, you're stronger than you know, and you're worth fighting for. Stay strong, and never stop believing in your own worth.